Good afternoon. Thank you for joining us today. My name is Shirwat Alwan, Associate Professor and Director of the MBA and Executive MBA program at the AUC School of Business. This here is session 4 in our Masterclass series, where we invite our international faculty from our network of partners to share with us their business expertise and insights, the reflection on the current situation we are all facing. Our highly ranked executive MBA is offered by the Triple Crown accredited AUC School of Business. Only 1% of business schools worldwide have this honor. The program is top of the region, and it's offered for many years now. It specifically caters to the needs of the executives and the managers in Egypt and the region, both in terms of the content we offer, because the material, the topics, the relevance of the topics is very important in what we, in how we choose our courses, but also again, the delivery, the application of the cases and the business cases we use, the compressed manner where we offer our classes in modular forms over weekends, with monthly intervals between you guys where you can work at your own pace and then join in for the sessions. So it's definitely designed for executives, and we do stay in close contact with our network of alumni. We're very proud to have a very strong network, and some of them are joining us today, and very excited to see their professor with us here. This is part of our promise for long life learning in the AUC School of Business, where we try to always be with you when you're facing challenges in something like the hardships you're facing today. I'm happy to welcome with us Professor Dr. Yassin El Shazly, Professor of Commercial and Maritime Law at Ain Shams University, also one of our EMBA faculty members for law at AUC School of Business, and partner at El Fishawi and El Shazly Law Firm. Yassin, Dr. Yassin, please, the floor is yours. You feel free to speak first or share your screen whenever you feel like it.
Yeah, okay. Thanks a lot, Shirwat, and welcome to all our participants, whether the MBA participants, as well as all of our public who are attending our session today. It's also always a pleasure to be part of the EMBA. I consider it as I've witnessed the launch of the MBA 2012. I've been teaching since this date, and I can see that our alumni is going on a day every year. So it's always a pleasure to be with them, whether in the Masterclass series or even in our normal classes. So without any further delay, let's speak about the topic of our session today: coronavirus outbreak and legal implications. Now, as you all know, now we have been told that there will be a normal life going on, and this normal life. Let me first just share my screen with our audience. I'm not sure.
I'll let you know when it shows.
Please, okay. So, yes.
There we go.
Yeah.
Yeah. Cool.
So now there's going to be a new normal life, and now we're all familiar with those terms: flattening the curve, social distancing, self-isolation, quarantine. So our business, our day-to-day work, and our normal business should coexist with those 4 new terms. Yeah. So we need to keep our social distancing. We need to deal with self-isolation and quarantine cases. So how could this affect your businesses? Now I'll take you through an overview first of the wider implication of coronavirus in different areas of law. And then I will tackle my topic, which is the force majeure and hardship, the topic that we have chosen for today's session. What are the differences? What is the fine line between the force majeure and hardship? How can you invoke it in court? How can you claim any of those 2 defenses? And then the allocation of risk. So can you, by contract, can you allocate the risk differently other than what is stated in the law? And then a grace period. Can you go to the court if you have some sort of delay? Can you go to court asking for a grace period? Which means that you will not pay. You are asking just for an adjournment for the payment. And then some of the variables, practicals and lesson learned from the variables of force majeure. And I will end my talk with the some practical hints for practitioners. Now, coronavirus is a normal sudden event, and the law and the legislation, and whether in Egypt or in other countries as well, or even international conventions dealing with international trade, are ready to address those concerns. But the concerns are different, and they are very, very wide as well. So that's what we are witnessing. So one of the topics that we will discuss today is related to the contract performance. So we have a force majeure, that I cannot perform my contract. You're having the cases of hardship, what are the grounds, and grace period. Then another interesting and important topic is the effect of coronavirus on labor relationships. And we have received many of, from our clients, from our colleagues as well, many questions related to the impact of coronavirus on the working environment. This covers a lot of matters, actually. There is an issue of what if one of my employees is sick? This would be considered a casual leave or sick leave, be considered part of the annual leave or not? What if he is self-isolated at home, or he had been placed in the quarantine? What if an employee is sick within his duty, which means that he is performing his work on normally, and then he had been infected? This is considered as working accident or not, which means I am liable as an employer to pay him or not. Another issue is the employer obligation. Now, the new normal life, as I have just mentioned, obliges the employer to take precautionary measures. So face masks, sanitizers, social distancing, even within the working place. So what is the consequences of the non-fulfillment of these obligations by the employer? Also, sadly, we have also witnessed what we call massive termination of the employment contract. Now, according to our Egyptian labor law, Article 196 addresses this issue, which means that an employer, due to the economic crisis, he decided whether to shut down fully or wholly, or partially or fully to shut down his establishment, or shrinking or downsizing his businesses. Now, 196 as well, we have received also questions whether it's applicable to or not to the actual situation, because this article, you need, in order to be within the scope of 196, to fulfill two main conditions. On the one hand, you have to do what we call massive or collective termination. You cannot terminate one employee or few employees saying that this is 196, this is massive termination, I'm allowed by the law. No, you have to do it collectively, which means that there is a quantitative test that will be assessed by the court in this case. Whether you do it immediately or according to what we call a layoff plan, both are acceptable legally. And we have seen some of the industry, some of the car industry, very famous brand, I will not mention the names, as well as airlines, they have decided or they have announced these types of plans. And the second condition to fulfill it as well is what we call the economic necessities. The economic necessity could be internal or external, which means in our case, coronavirus or COVID-19, it's an external cause, but it could be internally as well, that due to the actual crisis, there is no loss, there is no damage to your businesses, but you have decided to restructure, to merge, to be more competitive in the market, or to be more efficient in your day-to-day operations. So if you satisfy those two conditions, you can rely as an employer on 196. Now, also, from the labor law as well perspective, the payment. Article 41 of our labor law allows the employer to pay half of the salaries in certain conditions, which is a condition where you have an employee who reaches his workplace, but he cannot perform, not due to the fault or the attitude or the mistake of the employer, but due to an external cause beyond the employer control, which means you have your business is open, but your employee cannot perform due to the coronavirus. So you can establish that COVID-19 is one of the causes that goes beyond the control of the employer. You will allow to keep your employee and pay them half of the salary. If you go to consumer protection, this is also one of the topics. Now, of the topics related to the actual pandemic and COVID-19 crisis. Now, consumers, according to the Egyptian consumer law, I would also like to draw your attention that this law has been completely, majorly amended in 2018 by the law number 189 of the year 2018, replacing the previous law of 2006. So we have a new modern consumer protection law. More teeth have been given to the consumer authority as well in order to tackle violations and to restitute any claims by the consumer. Now, normally consumers nowadays, they feel that they are under pressure. So they will come back to you and say, okay, I would like to replace the products. I would like to restitute and have my money back. So this is the 30 days option. Consumers have the right to replace, restitute the products or services in the case if they discovered that the products or services are defective. Now, there are certain exceptions and variables in these cases, but yet this is the general rule. Now, misleading advertisement, misleading conduct, actually. Now, the misleading conduct has been introduced by Article 9 of the new consumer law of 2018. There is an exhaustive list of what is considered as misleading conduct. In advertising as well, we have witnessed cases of consumer protection, cases of false advertising when it comes to face masks, when it comes to sanitizers, misleading, and there is a very, very small, tiny fine line between what is a false advertising and what is a misleading, and what we call as a puffery, which is a verbal exaggeration of my product. I'm the best products in the market. I'm the healthiest product in the market. So we have witnessed some of these cases recently when it comes to the consumer protection. And let me bring two precedents from the French jurisdiction. Now, one of the mega market decided to limit the sale of face masks, saying that any consumer is allowed only to buy 10 face masks. Yet, this market or this hypermarket says in the same advertising states that, but if you are a holder of one of my loyalty card, you will be allowed an unlimited number of masks. Now, another precedent, definitely in the first precedent, this was considered against consumer protection law, consumer protection, and it could be considered as per the Egyptian law as misleading conduct or refusal of refusal to sell the products without any legal grounds. Another also issue was related to the promotional advertising campaign of health products, because it is limited by the law. You cannot promote medicine as you promote, for example, a fast food. There are some sorts of restrictions when it comes to the promotional advertising campaign related to the to health or precautionary or medications or vaccines. So basically, you cannot say buy a pack of masks and get the second one free. You cannot apply the same concept when it comes to advertisement of health products. Now, the list is still going on. Market organization and state intervention. And we have witnessed state intervention not only in Egypt, but in many states, even in Western countries as well. Now, what are the types of state intervention due to the COVID-19 outbreak? We can witness, or we have already, price fixing of certain products for the public order and for the protection of the health of the community. You can also face export and import restriction due to the same measures, whether for the health, whether based on health reasons or for safety or for food security. Compulsory licensing of patents, and this could be interesting for those who are working in pharmaceutical. States are allowed, or governments are allowed, based on the TRIPS agreement and based on Paris Convention as well, to intervene in order to issue what we call the compulsory license of patents. For example, patents of new vaccine over new medications, and this is granted by Article 23 and 24 of our intellectual property law of 2002. Yet there are certain conditions to be fulfilled, but the compulsory license as a venue in order that the state will use for in order to provide vaccines, with affordable prices for the community. Yet Egypt did not use it before, did not rely on compulsory license before. We have witnessed cases in other developing countries in Africa and Asia, and also Latin America. E-commerce. Now, e-commerce, our legal system up to now, we don't have a specified legislation to address all of the concepts of e-commerce. But as all of our businesses is going online, and as we are now transforming or going towards what we call digital transformation, then you have to expect cases related to cybersecurity, cases related to unauthorized access, cases there's embezzlement online as well, defamation, issues related to payment. So we have an obligation, and we have also introduced in our legal system the new cybercrime law of 2018. Yet we don't have a law dealing with e-commerce. One of the issues is the ISPs, the Internet Service Provider Liability. So the medium of exchange, for example, I'm a retail business. I would like to go and offer to my clients payment through online, so I recourse to an ISP. So what is the liability of the ISP in case that the product didn't reach the client, the product was defective, there was some sort of misleading or false information on the platform. I don't control the platform, I'm just selling through the platform. The issue is also of ISP, there is no specific legal provision, yet we recourse to the general rules of law. Lots of privacy concerns with the digital transformation. Privacy concerns for employee due to the fact that they are working from home. Free competition and free competition, and we always say that crisis is an opportunity for merger and acquisition deals. So how could you? What are the grounds according to the law in case of hostile takeover? What are the grounds that a business, or especially small and medium enterprises, can recourse or can rely upon in order to defend the existence? Cases of monopoly and dominant position, especially when it comes to the precautionary measures applied and when it comes to the health sector and food security as well. Defamation. We have witnessed one of the cases that there was some sort of rumors circulated about the spread of COVID-19 coronavirus in one of the factories, and it turned out that this is not true, and the rumors was done by another competitor who was behind it in order to ruin the reputation of one of the businesses of one of his competitors. So Article 66, unfair competition, you have non-exhaustive list. The Egyptian legislature put a general rule: any type of conduct which is against business norms and against loyalty that shall prevail in business is considered as unfair competition. And this is a very good ground for asking for compensation. Now, in order to finish my list, sorry for that, the list is long, and I think it would be longer as long as this situation will remain. Now, restructuring your business. Many of the businesses, now they suffer economic loss. The supply chain is not functioning as before. Operation as well as hitting badly. So what are my options according to the law? What are my options to whether to liquidate, to close my business? Our law recognizes what we call conventional liquidations as well as judicial liquidation. So we can liquidate by agreement or by court. But what are the options to keep your business? And also here again, we are lucky to introduce that we have witnessed the new bankruptcy law or the new restructuring law in 2018 as well. So as you can see, I'm mentioning, I'm updating you about the legislations, but I think those legislations or these legislations that have been introduced in 2018 are actually part of combating the legal consequences of the coronavirus outbreak. I think one of the important laws is 2018 law of restructuring. Before this law, we had a very severe, harsh bankruptcy system. What do I mean by severe and harsh? That it's not allowing you, if you decided to go bankrupted, not all of the merchants who went bankrupted are bad faith. You can go bankrupted due to the market, due to the business, due to the market fluctuation in the norms of the business. So it could be due to the reasons outside of or beyond the control of the company or of the merchant. But the system that we have inherited since 1883 till, and the actual Code of Commerce of 1999 was very harsh, which means that it was not allowing a merchant to restructure his business based on the famous Chapter 11 of the US bankruptcy law, and also redressement judiciaire of the French law of 1985. So people were not granted this option of restructuring before they ceased the payment of their debts. And also, before this new law of 2018, there was no fresh start granted for a merchant or a company who declared bankrupted. There is no fresh start, which means if you are declared bankrupted, you will not have a fresh start. You cannot come back again to the market. So this new law of 2018 related to the restructuring and saving of companies and corporations allow businesses to apply for a restructuring plan if you are suffering some consequences. Well, the major condition in order to restructure and propose this plan is to do it before you stop the payment of the debts. If you stop the payment of your debts, which means you are in the bankruptcy loop, you still have two options. You can ask for amicable settlement with your creditors, or you can ask for adjournment of the bankruptcy lawsuit or bankruptcy action. The maximum time that can be granted by our courts is 3 months, and it's as per Article 196 of the new law. Compliance issue, I will go quickly through compliance issue. GAFI and EFSA and EFSA, the Egyptian Financial Supervisory Authority, GAFI as well, allowing now free zones companies to enter, allow them to enter 50% of their products in certain sectors. So we have to be up to date tax declarations as well. So we have to comply with the new rules and announcements by the different regulators in the market. And then dispute resolution. Dispute resolution is it's a tactical choice where to go in order to have your case heard. Shall I go to normal court procedures, knowing that most of the courts are not functioning as normal? Shall I go to arbitration, which is practically on private justice based on agreement? You can choose it, you can have it on ad hoc basis, or you can report to one of the institutions, like for example, Cairo Regional Center here in Cairo, in order to get your case solved by a decision that cannot be revoked by court unless in the case of nullity actions, which is not reviewing on the merits of the case, but on your procedure grounds. Then you have other options. Now, if you go to court or to arbitration, most likely you are in a win-lose relationship. So whether in court or arbitration, there is a winner or a loser. If you would like to preserve your relationship, if you are more realistic for compromising, you still have other two options. You can mediate, which means you are having a third party to intervene and proposing a solution, non-binding solution, or conciliation. And in the case of conciliation, the third party is not proposing a solution to the parties of the dispute, but just allowing them to get a communication channel. Or you can directly be engaged in negotiation with the other or contracting parties. So these are some of the issues related to coronavirus outbreak and how could it interact with different areas of the law. Now, what we have chosen for today's session is only a small, tiny point of these topics, which is related to force majeure and hardship. Now, we all know that contract is the law of the parties, which is the famous Latin pacta sunt servanda. So if you have a contract, you have to honor the contract, you have to perform your obligation. But what the question is, what can I do in such a case of COVID-19 outbreak? What shall I do? I still have the intention to perform, but there is some sort of change of circumstances, and I'm not capable to perform. So if you go to Article 165 of our Egyptian Civil Code of 1948, we find that there are three cumulative conditions that had to be satisfied in order to rely upon a force majeure. Now we have to classify the event as unexpected, and the test is an objective test. So it's not unexpected to the debitor, it's unexpected in general. So the test is objective. Definitely Corona or COVID-19 as an event is definitely an unexpected event, not objectively speaking. And then this event will it will give a situation in which one of the contracting parties, he will not be capable to perform. He cannot be capable to prevent such event. So there is no alternative for him in order to avoid such an event. And then his performance is absolutely impossible, which means I don't have any other alternative. Now, if you apply these three conditions, so unexpected event, impossible to prevent, and the obligation itself arising from a validly construed contract. So definitely I'm speaking about the validly construed contract. So the contract is valid, satisfying the capacity condition, satisfying the consent as well as the object and the cause. So we have a valid contract, intentions of the parties are good, and they are willing to perform, and then this outside changing of circumstances and outside event beyond their control. So if you satisfy these three conditions, you can rely upon the force majeure. Yet, you have to prove it. You cannot go to court and saying that, okay, the media is speaking about force majeure, open the news, there is COVID-19 outbreak everywhere. There is a force majeure. This is not enough in court. You have to there is a burden of proof on the debtor to prove the existence and the extent as well of force majeure, not only the existence, but the extent. How does this event affect his normal obligation, his day-to-day business and his contractual obligations? Now, according to our civil law, according to Article 165, the force majeure will prevent the execution of the contract. But this will give rise to two scenarios: whether there is an absolute impossibility, which is absolutely impossible to perform, so the contract will be rescinded. The contract will no longer exist, and the contracting parties will go back to the normal situation before concluding their contracts. Or that the force majeure presents a temporary recession or a temporary obstacle for the performance of the contract. This is what we call that the force majeure, that the event of the force majeure is temporary. So in this case, our obligations will be suspended temporarily unless this force majeure is gone. These are the two scenarios that we can expect. Yet I will speak about the assessments, how we can assess based on our contracts that we have a force majeure. We shall satisfy first the three conditions, and then what are our possibilities? What are our options here? Is it complete non-execution of the contract, or it's a temporary non-execution of the or temporary suspension of the contract? Also, it's very important to know that according to our law, you can allocate the risk related to force majeure, which means that the parties of the contract, they can agree to exclude force majeure as a defense for non-performance of their contract. Also, they can arrange how this force majeure operate, which means that which means that we agree from day one in our contract that if there is a force majeure that will be sustained by any of the contracting parties, one of them shall notify the other within a certain period of time. They will engage, for example, for direct negotiation, and then they will recourse to court. So there is what we say in this case, that force majeure is not related to public order, which means that the court will never apply force majeure ex officio, which means that the judge will not, if the judge, for example, there is a case and none of the parties claimed force majeure due to COVID-19, the judge will not sentence or will not decide to apply force majeure. It shall be invoked before the judge, and it shall be proven as well by the debtor or the one who claims it. Yet there is an option to go beyond force majeure with a contractual agreement. This is not a public order provision of the law. Now, do we have force majeure only in our legal system? It's practically identical in most of the Arab world, and it's also in international trade, citing just quickly two examples: the Vienna Convention for International Sales of Goods of 1980, as well as the Hamburg Rules of Carriage of Goods by Sea, which Egypt is one of the signatory states. So that's, if you are operating as well internationally, you can rely, or you can find similar provisions related to force majeure. So what is your second option? What if I cannot claim my force majeure? What if, yes, the event, the coronavirus outbreak, definitely is unexpected, but I'm still performing? For example, look to the banking sector. They are still operating, yet reduced time of work, but they are still operating. So, which means they are performing partially. So you cannot rely on force majeure. Remember, force majeure is saying that impossible to perform. Now, here, that's what will lead us to the hardship. So hardship in Article 147, it's also unexpected event. Definitely, we are facing in both cases of hardship and force majeure an unexpected event. Yet this unexpected event, in the case of hardship, will not prevent or will not result to the fully non-performance of the obligation, but that the obligation will be excessively onerous, which means that the debtor will pay more money. He shall pay more invested, he shall put and inject more investment in his businesses in order to operate. So in order to satisfy the conditions of a hardship, you should definitely satisfy that you have an unexpected event, external and going beyond the control of the contracting parties. It is an excessively onerous to perform, but yet there is a possibility to perform. And this is one of the distinction between force majeure and hardship. So in a hardship, I can perform, but it's excessively onerous. So in this case, the law states that the judge has the right or may intervene. And may intervene to do what? To rebalance the contract. And let's see the differences as well when it comes to the consequences of force majeure and hardship. Now, on the hardship, what we have seen that in the case we have satisfied the three conditions, we're having only two options, whether temporary suspension of the contract or the contract is totally relinquished. Now, in the case of a hardship, the contract will still be going on, but the judge was allowed to intervene in order to rebalance the economical gap between the parties due to the hardship. One of the major differences also, and I will add here, related to the hardship, any agreement to the contrary is void. So you cannot exclude hardship defenses. Unlike force majeure, force majeure can be excluded as any defense. But unlike the case of a hardship, you cannot exclude it as any defense. Now, economic hardship is easily to be proven if only have, as I have just mentioned, excessively onerous. Your obligation performance is excessively onerous and is also affecting or causing as well a gross damage and loss for the debtor. So this is the cases of hardship and quickly, just in order to keep the time, of hardship and force majeure under Egyptian law. Now, practical scenarios. Did we witness any unexpected event before? The answer is yes. So you don't have to panic when it comes to the legal measures that will help your businesses to survive or to actually get over the coronavirus outbreak. This is not the first time that we have witnessed this in our legal practitioners. Now, let me take an example of the war. Now, I'll give you some scenarios as well. Now, war. Let me take one of the scenarios in our regions, the first Gulf War, as we do remember, between Iraq and Iran, lasted from 1980 till 1988. Almost 1 million persons lost their lives. Financial damages actually reaching more than $400 billion US. It's one of the worst crises politically and military that we have witnessed in our region. So one of the consequences, why I'm citing this, because I'm speaking about variables here of force majeure. Why I'm citing the Gulf War? Because one of the consequences of the first Gulf War is the deterioration in the oil and gas market, which means the decrease of the prices. And if you do remember, during this war, and I think if I'm correct, in the fourth year of the war, we have witnessed what is called the war of vessels, that the two countries, they have decided to destroy the oil and gas vessels passing through the Arabian Gulf. Almost 250 oil and gas vessels have been destroyed. And this is actually was one of the causes that the United States launched under President Donald Reagan in 1987, one of what is called Ernest 12. It's one of the largest marine campaign in order to secure the marine navigation in the Arabian Gulf. So the situation is like this. You have war, you have financial losses, you have an international crisis, deterioration of oil and gas. Now, far away from the Gulf, an oil and gas, a state-owned oil and gas company in Hungary was under the contract with the Yugoslav pipeline, crude oil pipeline. And they have decided, and they have said, we are not capable to perform. We cannot deliver. It was a crude oil. We are in the downstream of oil and gas business, downstream operations. And they said, okay, we are not capable to perform. Look to what is going on in the war in the Gulf and this crisis, and the US, the Marine, and how they are securing navigation and deterioration of prices. So this is definitely, war is definitely an unexpected event. You cannot state otherwise. And our oil and gas business is actually ruined. So sorry, we cannot perform. Now, surprisingly, now the court said, this is definitely an unexpected event. We do understand what's going on in the Gulf, but in your businesses, this is not unprecedented event, which means in an oil and gas business, you have seen before these types of fluctuation of oil and gas prices. In other words, what I'm trying to say here, if you would like to rely, if you are in the oil and gas business and you'd like to rely upon COVID-19 as unexpected, you definitely fulfill the first condition of force majeure. It's an unexpected event. But yet, how can you prove that this is unprecedented? We all know that there is a decrease actually nowadays in the barrel price below, I think, $30. Yeah, but this is not unprecedented in your businesses. So the defense will not sustain, that will not stand for a long period of time. Force of nature, what we say, an act of God, this is very limited now. This is cases of earthquakes, volcanoes, tsunami that destroying a part of a country. And this is also one of the cases of force majeure. But I would like to take another scenarios from Egypt this time. And it is related to the revolution. Was it considered the force majeure? And definitely we do remember the 25th of January revolution. The revolution, normally we can say that it started on the 25th and it ended on the 11th of February, if I do remember correctly, when President Mubarak stepped down. So one can say that during this period, this is a force majeure. Now the answer is no. It can be longer than this. And we have seen actually jurisprudence in Egypt confirmed by the Egyptian Cassation Court in the tourism sector specifically, that the revolution as a force majeure lasted till 15th of July 2012. So the appreciation of the length of the force majeure differs according to the businesses. So you cannot rely that this is, yes, unexpected event as a revolution. This is the period the president stepped down. So we're back to business again. Our contract shall be performed as before. The answer is no. There are lots of variables when it comes to revolution as unexpected event. And we have seen also another jurisprudence in a different sector, which is related to insurance, that the court said that the force majeure lasted in the case of insurance till the 7th of January, not only the 11th. And we have seen also when it comes to force majeure in courts, because during this period of time, we have witnessed similar scenario that the courts have been shut down, similar scenarios that the one we are witnessing today. So we have some sort of periods to be respected in order to file a claim before the court, in order to file an appeal, or to go to the cassation as a challenge. So during this period of the closure of the court, of the courts, our judicial system was not functioning as normal. So, which means that these period, for example, the 40 days to appeal will be extended the same amount of the suspension of the force majeure. So we have seen also in this particular area, we have seen a jurisprudence, a precedent saying that, yeah, but the courts operated normally after the 7th of February, 7th of February 2011. So you cannot rely, you cannot claim any suspension or any delay, whether filing an appeal or filing a challenge before the cassation court. Now, two more scenarios, if I still have time, Sharwet, yeah? Two more scenarios or two more events unexpected, legal measures. Now, legal measures, yeah, if I still have the time, just two more cases. Now, legal measures. What if I'm operating in a country and due to the COVID-19, new laws had been enacted, new legislations?
Sure, we do have time. We'll take questions in 5 minutes.
Okay, thanks, Shurat. So we can expect that there are new laws that will be enacted in order to protect, for example, the health of the citizen, restraining order, for circulation between governorates, travel ban due to health issues as well. Food security, for example, could be one of the restrictions in import and export in order to keep the food security, which is a public order and public need. So law, what I'm saying, that law could be seen as a force majeure. Legal measures could be seen as unexpected events. And let me bring an example from Libya, just a neighboring country. Now, there was, I'm stating also another case in oil and gas sector. It's one of the famous cases. 1980, we have Sun Oil, an American company, signed with the NOC, with the National Oil and Gas Company in Libya, the Libyan Oil and Gas Company, an EPCA contract, exploration, production, sharing agreement. And then we all know that during the 80s, the United States decided to apply what we call a travel ban for Americans to travel to certain countries, including Libya. So the Sun Oil, the American company, claimed the force majeure. And they're saying that we cannot perform anymore. We have a travel ban. I cannot bring my American engineers, my American employees to Libya. There is a travel ban. This is an unexpected event. We did not expect this event when we have signed the contract, so we cannot perform. When this case went to ICC, it was an ICC arbitration, International Chamber of Commerce, ICC arbitration case. The arbitral tribunal did not deny the existence of unexpected events. In other words, saying that, yeah, this travel ban by law, by new law, it is an unexpected event. We are fulfilling the first condition of force majeure. Yet, there is an alternative in the market. And the NOC, with this, the claimant in the case, the Libyan oil and gas, proved to the court that other American companies, I repeat, other American companies that were operating in Libya during the same period of time, they have replaced their employees by non-Americans, which means by locals or employees from other oil and gas companies, and their business is kept going, which means you cannot claim impossibility of performance. This is, once back again, the alternative option in order to prove a force majeure. My last example comes from the economic crisis. And I would like to recall here, our financial system and our economic system witnessed many of economic crises, but one of the recent was the subprime, the Lehman Brothers bankruptcy in 2008 in the United States, and the subprime issues and the real estate market deterioration. This was also seen as an unexpected event, but the assessment in most of the cases of economic crisis related to the subprime issues in 2008 and the bankruptcy of Lehman Brothers were actually more lenient toward an existence of a hardship, not a force majeure case. I think I can stop here by giving you, and I can end my, I don't want to be longer than this, and I think I can end by some practical tips and hints to the actual COVID-19 when it comes to only 1 point, force majeure and hardship. So you have to ask yourself, you have to do an internal assessment, whether you do it through your in-house counsels or your lawyer. Now, open your contracts, check whether or not your obligation, you are under force majeure or a hardship. Are you impossibly not capable to inform, or you are still capable to inform, but your performance will be more onerous? Also, ask yourself, did I agree in my contract to a force of majeure allocation of risk clause or not? Which means that we have agreed from the beginning to exclude it as a defense, or we have limited or shortened its extent. And then choose carefully your forum where you will like to file your case. And there is a lot of variables here, cost and time analysis. Shall I go to court proceedings? And our court proceedings in Egypt are not that expensive. Or shall I go to arbitration? Might be more expensive, but it will be quicker to resolve my dispute with a final and a binding decision by competent experts, not necessarily lawyers, by the way. Or I would like to keep my relationship with my counterparties, which means I don't want to escalate. I want to go to court or arbitration. I would like to keep my win-win, which means relying on mediation and negotiation. Always remember that when you go to court, force majeure is not related to public order, which means it has to be proven. And I would like to end, and I'm saying this as a lawyer as well, not only as a law professor, that always remember that a bad compromise is better than a good lawsuit. Thank you.
Oh, typical ending point. Thank you. Thank you so much for this valuable session. I do have to say your opening 3 slides that kept on listing the issues and the implications of what we're going through got us a little bit depressed, but I do have to admit that I'm very keen of retrieving after the session goes back and the session is recorded, that I would go back and carefully look at this list, because the grouping you have is very useful. It points to issues that we might, have not thought about yet, because we're still looking very closely, at our feet right now. So thank you very much just for that list. It's very valuable. And I think if you retrieve it again and you find the groupings you have, also very helpful in the way that you can start addressing issues according to the hits and tips. We're still opening up the Facebook for questions, but for now, one I have is the timeline or the dynamics. We are dealing with a evolving situation. Every 2 weeks, our government produces new regulations, restrictions, whether retracting or releasing, or going back and forth and stuff. Where do I begin? When do I begin to think about, this is my right, the dynamics of a hardship and the definition of a hardship and force majeure, as you explained it today, differs based on what goes on today versus tomorrow. How does this factor in the timeline? I mean, the facts are very nice, but how do I figure it out?
Thanks a lot. Thanks, Loretta. Very practical question. Now, what I didn't say that those both situations, force majeure as well as hardship, are interchangeable, which means I can start by a hardship saying that there is some sort of onerous on me to perform, but then due to the time and the actual situation, it could be changed to a force majeure situation. So it's a matter of proof once again, and the possibility of performance and the proof before the court depends on what? Depends on assumptions. What are the assumptions that we have? Now, if you look to and this is a very, very vital document in order to assess your business, the bi-weekly Prime Minister Declaration or Prime Minister Decision. Now, look to the first Prime Minister Decision at the beginning of the crisis. We can see that more of the business were closed, shut down, the curfew was longer than we have expected, right? And then look to that we have decided to reduce and shorten gradually those measures. So this is the typical some sort of assessments. But for example, if I'm in the entertainment business, my force majeure is still there because all the theaters, cinemas, they are shut down. If I'm in the event businesses, my force majeure is still there because based on in these decisions issued by the Prime Minister, I'm shut down. I cannot perform. I'm closed. I cannot actually operate. Otherwise, I will be under violation of the law. But look to the banks, for example. Take an example of the banks and actually hotels and tourism sector. We have seen some sort of fluctuation from a force majeure to maybe a hardship, because now we are operating, and the hardship, what is more onerous now to a hotel is to provide sanitizers, face masks. This is more onerous, which means more investment and decrease of value as well. What is the value that has been decreased? And it cannot be actually 100% occupation. I cannot achieve the 100%. We have seen 25, and I think today or tomorrow we will witness the 50% occupation in our in the hotels. So it's an evolving situation, as you had just correctly mentioned, and you have to do this assessment. Otherwise, you cannot say force majeure point. No, the situation is evolving, and those decisions issued by the government, by the Prime Minister, as well as the reassumption and as well as the resumption of working courts and other types of sectors is alarming for us, that we are more or less leaving or departing from the force majeure situation towards a hardship which will allow us to negotiate and rebalance our obligations. It is the objective on a hardship to do what we call economical rebalance of obligations of the parties.
So many follow-up questions, but I started getting some input from Facebook, and I do want to make it fair for everyone. So I have a question from Mahfouz Amara. He's asking, what is the situation with the insurance companies in Europe? Some insurance companies are refusing to pay their clients. How does this work out in Egypt? Do you have any information on this?
Thank you for the question. Now the question is, what is the insurable interest? Now you have to look to your policy. Now this is a very tricky, because we have witnessed this question as, thank you Mahfouz for the question. We have witnessed a similar claim during the revolution, during the 25th of Jan. Now, is revolution considered as a force majeure or not? Is it covered by my insurance policy or not? And it was a very, very good ground for claims. Now, COVID-19 is unexpected. So what is the interest which is subject of the insurable interest subject to the insurance policy? And based on this analysis, we can give you a practical answer of the question. But yet, force majeure, remember, allocation of risks can be excluded, which means that it could be excluded from my policy to rely upon force majeure as affecting the insurable interest.
Thank you. You mentioned the variables related to force majeure. Can you expand on that a little bit? What exactly, how do we work them out? You gave examples of everything else but the pandemic of Corona. So can you reflect on that?
No, thanks, Sharwat. I have just recalled these scenarios in order to give us insights. How we will be dealing with similar unexpected event as the war, revolutions, legal measures, and economical hardship as well. But the variables are very important. Now, the one important variable during the fulfillment of or satisfaction of the condition of force majeure is the alternative. Do I have another alternative in order to perform or not? This is one of the important variables that you have in the phase of proving or not whether or not we have force majeure. And after we have maintained or after we have satisfied the force majeure, another important variable here and afterwards is the length. How long this force majeure had been lasted? How long it will be considered? Is it since I think we have started to have the curfew third week of March, yeah? And still the curfew is still going on, by the way, till mid of June. But does this mean that all of the businesses in Egypt or any other countries in a similar situation can claim directly or per se the force majeure? The answer is no, depending on whether or not your businesses had been affected during this period. If you are still operating, but limited period of time, more investment, more money to be put in order to keep the precautionary measures, or even to allow social distancing, or to allow digital transformation of your businesses. Now, here is your second choice, your second alternative, which is the hardship, in order to economically to get the economical balance. So the assessment of the length of the effect of the force majeure is vital.
Now, in light of that answer, in your last slide, you mentioned some kind of formal ways like courts and arbitration, and compared to more like negotiation or friendly discussions. We can even go back to that slide if it's okay with you. So.
The dispute resolution.
Yeah, dispute. So my question would be, one more, I think. So would there be
the grace period?
I mean, would there be a recommendation when for some industries or some sectors to go this route versus another? Is there a generalization of it? Because, you know, someone's loss is someone else's gain in some cases. So how do we work this out, and how do we make sure that what I use for me is the right thing to do?
Now, going to court, thanks, Sharwat, going to court is your normal venue. It's your natural judge going to court. Most of our businesses and most their jurisdiction, the jurisdiction mainly is in economic courts, well equipped by expert, not only judges, an expert as well, but we are facing some challenges for the online dispute resolution. Are our courts capable to do the online court proceedings or not? Now, if the court choice could be longer, by the way, but it could be cheaper. So this is what I have said, cost-time analysis. But then you have an arbitration. Arbitration is another venue in order to settle your disputes, but it's based on agreements. So you should have an arbitration clause in your contract, whether to settle such a dispute through an ad hoc tribunal or through an arbitrational institution. Now, could be faster than the court track, more expenses because you have to pay. This is your private justice. You have to pay for everything, not only the fees for the center, but as well as the fees for the arbitrators. But you will have a decision one stop. It's final and a binding decision. You cannot review an arbitral award according to the Egyptian law, unless you have procedural grounds according to the arbitration law of 1994, which means you cannot review the merits of the case, but only if there is procedural grounds, you can recourse to what we call a nullity action. Now, it's more convenient, and we have seen most of the arbitral institutions, they have already introduced online and e-meetings and e-sessions as well, electronic sessions and meetings, and all of the hearings, even cross-examinations can be easily done electronically. So they are, because this is the private business part, so they are more capable to actually to accommodate the consequences of the COVID break. Again, this is your analysis, and as well the existence of an arbitrational clause or arbitration agreement between the parties. I highly advise, this is the time to mediate, this is the time to negotiate. Now, as I told you before, good compromise or bad compromise is better than lawsuit, because if you have decided to arbitrate or to go to court, now we have lawyers on board, and you don't know where you, and I'm speaking as a lawyer as well, and you don't know where the case will go, and what are the defenses, and how long it will last, and whether or not we would like to recall an expert witness, and the other party will recall another expert witness, and then we'll have a cross-examination, and then evidence, and then exclusion of evidence. So we cannot tell you that you're going to file a lawsuit, and tomorrow, and for example, in 2 weeks, you have a final decision, or 1 month, or 1 year. It's not predictable. You can limit your time frame of arbitration by time, but not often in big conflicts, but it could be possible. So this is the time to bring a mediation. And hopefully, up to now, we don't have a mediation law. We have a draft law for mediation in Egypt. But Certica, for example, Cairo Regional Center introduced mediation rules. And also there is a center in Gafi, the Free and Trade Zone Authority for mediation and settlement. This could be the right time to settle. Maybe you will lose in the settlement, but you will keep your business going, and you will avoid paying fees, whether for your lawyers or for arbitrators and arbitral institutions.
Thank you. I guess this answers, we had Ali Abdul Hamid, thank you for the question. I hope he was, this responded to your concern. She's saying, do we just avoid arbitration in this period because of the costs and things? And I think you pointed out with some very good tips of where to go. That's very helpful. Moving from contract management to HR or employment issues, I have a question from Abdurrahman Abdul Jalil. For which extent can we expect the force majeure to work in favor of the employer? Can he deprive me as an employee from every right that I have just with a force majeure situation and a good lawyer at his side?
Now, depending on the employer, in order to address the question from both sides, employer and employee. Now, what can I expect? And also depending on what I have been consulted regarding the actual situation. Now, employers, they will come to us and say, yeah, the crisis, that this is not only pandemic, this is not only a health issue, this is as well as an economic crash. And we are all speaking about economic depression as well. So please, I would like to whether terminate, or restructure. Now, termination is related to labor law. And they will come and say, I would like to, and they are both linked. Why? Because in order to invoke the massive termination or the termination condition based on Article 196 I just mentioned, you have to satisfy that there is an economic necessity. So it's easily, you can come and say, there is COVID-19, I cannot operate, I'm having losses. Or there is an issue of, okay, due to the losses, I need to restructure, I need to merge, please, some of my sectors, some of my departments will be reduced. And we have been seeing some of, on the outsourcing and the supply chain, there will be a major change. Maybe Sherwat is better placed than me to speak about supply chain, but the outsourcing and the day-to-day business will definitely change. So please, why I do have this IT department, for example, I would like to outsource, and I would like to do massive termination based on the 196. So these are the two variables to assess. If there is really an economic, and this is the control and the discretion of the court, whether the business and the establishment was under really an economic necessities to, for example, to lay off most of the IT department in my scenario, in my hypothetical case, or not. Was it more or less favorable for the interest of the establishment of the factory or of the enterprise to do such an act? And whether or not the plan of laying off is objectively had been adopted. This is not an awkward situation. And as I told you before, major operators in the airline industry as well as in the automobile industry, they have already applied such a plan. Now, in your case, Ali, your enterprise, your employer did not do a massive termination. You go to work every day, but you cannot perform your obligation due to the COVID-19 outbreak. For example, look to the case of cinema, look to the case of entertainment, look to the case of sports clubs, of gymnastics clubs as well. You are willing to go, but you cannot perform, not due to your act and not due to the also act of the employer, but due to the COVID-19. In this case, you can rely upon Article 41, which means that your employer will pay you half of your salary. So you will be allocated half your salary. Massive termination provision, you cannot rely, you cannot be within the scope of 196 if you only fire 1 or 2 employees. This is a plan that will be adopted whether immediately or not.
Thank you. I see. And you did mention it before. We're running out of time. It is already on the clock, but there's a question on how to, from Amir Fawzi, about e-commerce, which I think goes beyond COVID-19, in my opinion. And when you even spoke about it and all the lag between the the legislation behind cybersecurity and how it's happening, you did talk about it. But if there's something you want to add towards that, so we can respond to his concern about e-commerce, the fact that we're all going to be moving mainly in that area.
Now, my major concern when it comes to, thanks Amir for the question. Now, my major concern is the platform liability, the liability of online payment platforms. Now, how would you satisfy it? How do you build your case? What in the case there is the liability of the online platform? How could we satisfy this? We need the business to be kept running. We don't like to keep down, to take down all the platforms with legal measures. Some of the new trend is a very simple way. It's a notice and a takedown. What if, for example, a platform is actually offering to sell, I would say, some falsified products or products that are not real or not authenticated? And this is one of the major things that face masks. What are the we have seen through WhatsApp and other mediums as well as on online as well, and maybe Facebook pages. We have seen people saying that, please, I'm offering you, this is the best offer. Please come to my page, or please, I would offer you the best deal ever when it comes to face masks, sanitizers, etc. This is below market price, and then these products are not authenticated. They have not been checked by the health competent authorities as well, and there is an issue of consumer law. So, what is the obligation of the platform? I'm not only speaking about ISPs in social media like Facebook or Twitter or Instagram or WhatsApp. I speak about platforms built up by, for example, startups company or by SMEs in order to facilitate the exchange of products. This is a real concern when it comes to the liabilities of these platforms as well.
Okay. Do we have time for one more question, Dr. Yassin?
Yeah, please.
All right. Well, it's about airlines and expectations on the airline industry. And we can take it as a case actually about what's happening. And from both sides, we understand the struggles airline industry is going through, and then us as consumers. How does that fare out, and what's your expectations in that one?
We have seen, actually, thanks for the question. We have also witnessed
Adil Shazly, thank you.
Yeah, thanks, Adil. The IATA announced the declaration about the actual transportation crisis, and the whole sector is going down. The major losses that we are witnessing, the major cases of force majeure is in tourism, as well as events, entertainment, and also supply chain, more or less, and hardship, and also in the airlines. Because how you could perform if the airports are closed? How could you perform if you have limited numbers? So there is an issue of force majeure. We have heard that some of the airlines could be declared bankrupted. Also, state intervention. I have mentioned state intervention in the market because, as you know, in a free market, in order to keep the balance, states are refrained to intervene in order to keep the free competition. But we are expecting to see states intervening more in the market in order to keep businesses. So the situation in our case, it's going towards more a force majeure case. So that's why most of the airlines, they are offering their clients whether, please, okay, our contract does not exist anymore, whether you will have this as a credit for a future relationship, or the contract has been relinquished and I will pay you back the ticket. But don't look we don't have only to observe airlines only on the passenger to passengers level. Look to the airlines for the cargo level. Look to the airlines when it comes to postal services. So you'll find that the damages are more.
We could go on and on, of course. Yeah, I think your valuable and generosity with your time. And the session is recorded. Please do retrieve it. And are you open to people emailing you questions? Can we share your email if someone requests us, Dr. Yassin?
Yeah, please do.
All right. Okay. Thank you very much. And thank you for joining us here at the Executive MBA program at AUC School of Business. Thank you very much.
Thank you.